topic will be on patent law and competition law. And we had also mentioned a brief introduction on what we plan to cover. Now, the decisions on patent law and competition law come at an intersection of technology that has to be used by others. I will explain this. In the initial note that I'd sent, I had mentioned two types of technologies where there could be some sort of interaction between competition law and patent law. One is with regard to standard essential patents. We had already mentioned that. The other is with regard to genetically modified organisms. Now, how do these two branches of law come into play? Now, when it comes to standard essential patents, and we'll be looking at one of the prominent cases on standard essential patents, a standard implementer will have to use the patents that are being licensed or offered for a license by a standard essential patent holder, what we call an SEP holder. So the SEP holder would offer to grant a license on FRAND terms, which has to be settled between the parties. But even whether the license comes into play or not, the standard implementer would have already started using the technology, because that is how standard essential patents work in the telecom sector. So we saw cases where Micromax and Intex started using the patents or the technology, and later on, Ericsson approached them asking for royalty, which ended up in an infringement suit. In response to the infringement suit, Micromax and Intex filed a complaint before the Competition Commission. So you will find that in some cases involving technology, where the technology has to be used by others. So in the case of standard essential patents, the technology has to be used by others because standard essential patents are used by standard implementers. The mobile phone or the mobile handset manufacturers are the standard implementers, or they put the standard into practice. To that extent, in some streams of technology, you have this issue of people using others' technology or people using others' patents. A similar domain, or a domain in which you have this in effect, the issue of one set of technology users using the technology which is patented by another person, is where you have genetically modified seeds. We had seen that in the Monsanto case, where Monsanto filed cases of infringement against certain seed manufacturers. The seed manufacturers took the case to the Competition Commission. Again, you see a parallel here, because in the case of standard essential patents, the standard implementers had to use the patent. There was no other way for them. So in the case involving genetically modified organisms, Monsanto controlled the seed, but downstream users, the seed companies which manufacture the hybrid varieties, had to use Monsanto's technology. And Monsanto initially licensed that technology. Then when the prices didn't suit them, they went on to terminate those licenses. So understand that there are particular technologies, such as telecom technologies, where there are standard essential patents held by the patent holder, which has to be used by others. The standard implementers, because it's an adopted standard, they can't use anything else. They have to use it. Similarly, when it comes to genetically modified seeds, you have again a situation where there will be people who develop new varieties using these seeds, or whom we call downstream users, who have to use these technologies. So if you can think about a technology or a field of technology where patent holders necessarily will have to allow others to use it and then negotiate a license, or by design will have to negotiate a license and then allow others to use it, you can see an interface or an interaction between patent law and competition law. So patent law and competition law normally interacts in situations where people are forced or compelled or have no other option but to use a particular technology. Now, we have seen that in the case of standard essential patents, because the telecom industry operates on common standards, and the standards are first adopted, and then everybody has to use those standards and get the technology licensed on FRAND terms. Similarly, if there are genetically modified seeds which are being sold to hybrid variety, the companies which develop hybrid varieties, then by necessity, they will have to use this patented technology, because without using the seeds, they cannot develop the varieties. And without developing the varieties, they will not be able to sell it further to farmers. So you will know that competition law and patent law issues come up only in, or to put it in a better way, they come up predominantly in fields of technology where there are downstream users or there are standard implementers. So with that, let us look at what we have to cover